Welcome to Queen City News Plus. We got anchor Brian Blakely here.
And I'm Chief Legal Analyst Khalif Rhodes.
Yeah, Khalif, good to see you. We got order in the court. Court is in session, and you know the deal. We got three subjects, legal topics, issues that we're going to be talking about. We're going to be talking about a stand your ground case out of South Carolina. Also going to be talking about Supreme Court taking up a case involving the Catholic school and the LGBTQ rights. But first, we want to start off with the Trump administration. They launched an online portal here to begin refunding billions of dollars in tariff refunds. Now, it comes to 2 months after the Supreme Court. It struck down the Trump tariffs here, and now the administration is beginning to refund $166 billion. And businesses can start doing that, and they've already started to do that, and they need to do that sooner than later if you want to get that money back.
Brien, you are all over it. Let's start with the Trump administration didn't decide on its own. Hey, we implemented these tariffs, and you know what? Out of the goodness of our hearts, we're going to give you this money back. No, that's not what happened. The Supreme Court,
$166 billion
yeah,
worth.
just take it back. Yeah, that's not what happened. The Supreme Court had to make a decision in the February 20th, Learning Resources versus Trump, that the use of the International Emergencies Economic Powers Act to implement the tariffs was unauthorized, and because it was unauthorized, they kicked it back to the Court of International Trade. That judge on March 4th issued a sweeping order requiring the government to finalize the cost of bringing millions of shipments into the United States without accessing the International Economics Power Act. So basically, the judge in his order wanted them to start issuing the refunds in real time in court. They had a hearing 2 days later. The government comes back and says, Your Honor, we do not have the capacity or the ability to respond in that fashion for a number of reasons. You got 166 billion, right? You got 330,000 different businesses, and you got 55 million different entries. They're like, we need time. Judge gave them 40 days. Guess what? Today's the day. So that portal is now open, and folks were sitting there with their finger on the button, similar when you're trying to get those tickets on Ticketmaster to the next concert, for sure.
But it is going to take some time here for businesses to enter. They should have already been doing their due diligence and getting their paperwork ready to go. There's a process when you file online to get start seeing your refunds. There's companies all over the country right now, including some here in the Carolinas, that are starting to do this process. And there are some legalities concerning it as well.
I mean, the first thing is you want to identify eligible entries, right? So if they were outside the window when this tariff was implemented, then obviously that's not going to be one that you can now say, hey, give me the money back for this tariff that I paid. It has to be specifically targeted to the things that were brought into the country that were hit with a tariff and that you paid. So you talked about companies during their due diligence having your paperwork ready. If you were following and if you've engaged in this process, you know you doled out hundreds of thousands of dollars or thousands of dollars, depending on your size of business. And hopefully you've been watching, hey, Supreme Court ruled they can't do that. What's the next steps? Okay, the second court ruled they got to give the money back. Okay, what's the next steps? And now you see this website has popped up and you can add your documents on there, but you hopefully had your paper trail ready, having the supporting documents that showed you paid, that showed the money came out of your account, and now that you have allowed to preserve your eligibility. That's a critical step that had to be done within that 90-day time frame of the things getting the tariffs being paid. That's under 19 USC 1514. The goal was that you wanted to ensure that this was final, so now you can appeal this request. And then you have to wait for them to be submitted through this application in this portal. And again, we have a portal now, so they can do it.
Right, and it's coming through the U.S. Border Customs and Border Patrol here. They're the ones operating this, so it's going to take some time. As you were talking about, millions and millions of entries, they're going to have to be processed. So they have to have a lot of people that are going to be able to do that processing. So when will the businesses see money? And also because of the tariff situation, because some of the companies passed on the cost to the consumer, some did not. But what will be the benefit here be to the consumer?
A couple things. I'll say first, Brian, that the process is not guaranteed. So let me start with that. You're submitting your documentations, and the government does still have to approve the request to return it. So hopefully your I's are dotted and your T's are crossed, and that all your documentation supports it. Refunds are expected to be given back to these businesses in that 60 to 90-day time frame. And the government anticipated this. They said, because instantly the judge wanted them to start the process that day. They didn't have the infrastructure ready. And so they anticipated that there would be chaos, that there would be confusion. in the Supreme Court, Justice Barrett said the same thing. Hey, I think this refund process could be a mess. That was her words. Judge Eaton says, I believe that there will be no chaos associated with the provision of these refunds and that it will not result in mess. One other thing that he said, and I thought it was crystal clear, he says, the law is clear. The duties were unlawful from the moment they were imposed. And that means that every single cent of IEEPA duties must be returned to the importer. So you asked the question, how will consumers and when will they get their money back? Based on this judge, they should be getting it back instantly, and it should be every cent because they were unlawful. Now, regarding consumers, I think that's going to be another tricky issue. It depends on if the consumer, if the business passed it on to the consumer, or if the business just ate the cost, as if some of these businesses have done, and then, maybe took up the price to their item, but didn't charge their customer a fee. So something that maybe was $10 before the tariff was implemented, and now was $12. We didn't pay the tariff; you just paid a higher fee. So you're not going to see any additional changes now. You've probably seen it with the price going back now. But there were customers that businesses charged them the fee. I'm one of them. I had ordered an item from Canada. That company got it from China. So by the time it got to me, those tariffs were implemented. They told me, hey, before this can come to you, you got to pay a $250 fee. I told them, hey, I don't want it. Send it back. Keep it, because I don't want you.
You had to pay the tariff. You had to pay that fee. They asked you to do it.
They did, and I rejected it. And the crazy story is they still delivered it and then asked me to pay the fees later, which we're still trying to figure out.
Oh, boy. Glad you're a lawyer.
Yes. Well, I mean, acceptance is required, and I clearly, explicitly denied accepting the item because I think the cost was, maybe $100 more than the tariff. So I'm going to pay double for the item I'm trying to get it? No, I'm not going to do that.
That's what this is a cause, this kind of issues right here.
It did. It caused chaos, and it really had me thinking, okay, do I really need this item, and do I need it to come from another country? I mean, just because I'm saving a couple bucks and I end up spending double, that's some of the things that you thought about. I think for the most part, consumers didn't get the payment portion of it. That was given to the businesses, and the businesses are now saying, hey, I want my money back.
Yeah, good stuff. Good luck getting your money back. Good luck for those companies getting their money back. That portal opened this week from the Trump administration on those tariffs. And coming up, another story we're going to be talking about in our second segment today, Khalif. That is the Supreme Court has agreed to take up a case of a Catholic preschool that is challenging its exclusion from a Colorado universal preschool program. It's all regarding LGBTQ rights. You're watching Queen City News Plus, an Order of the Court with Khalif and Brien. We'll be right back. Welcome back to Order in the Court with Khalif and Brien. And our second topic today as court is in session, and we're talking about the Supreme Court. They're taking up another LGBTQ rights case here involving a Catholic preschool program that's challenging the exclusion of a Colorado universal preschool program. Talk to us a little bit about that.
This case has a number of things that are issue, and there's a couple of things that won't be on issue. So the case is St. Mary's Catholic Parish versus Roy. The Supreme Court granted cert. That means they'll grant an opportunity for this case to be heard in front of the court. You only need 4 votes to get cert granted. They got the 4 votes, so cert will be now, in this case, will be argued before the court. It's the question presented, and I say it like that because that's the legal term. Anytime there is a brief that goes before the Supreme Court, you have to ask them a question, and then you have to allow the court now to answer that question. So the question presented here is, can a state exclude a religious preschool from a public benefits program because the school follows a religious belief that conflicts with the program's non-discrimination rules? And so largely, this is the 50-foot view is this a violation of the free exercise clause? Does Colorado violate the First Amendment by denying funding unless the preschool agrees the policies that conflict with its religious beliefs, basically allowing LGBTQ families and children to go to that school? That's going to be the question. And is it unconstitutional religious discrimination, or is it just neutral condition on public funding?
So where do you see this case going, and what's the timeline on this when court takes up a case? Friday, April 17th is when they decided they were going to do this.
Yeah, I mean, I think that this will obviously be in the next term, so they're deciding that they'll hear this. They'll hear this case not now, but next term, and then I believe we'll get an answer, 60 to 90 days after that. But I think this is telling because there is a case where they've already ruled this employment division versus Smith. They have to apply that same standard. Is it neutral and is it generally applicable law? Usually valid, even if there is a burden on religion. And the reason I bring that up is because this is what the Court of Appeals has already said is being done. They're saying that there is no religious targeting, there's no religious discrimination, that the state of Colorado is just doing what they are allowed to do under the Supreme Court's guidance from this employment division v. Smith case, which says, hey, is it neutral? Is it targeted towards everyone? Is this something you're only sitting at, churches? Or are you doing this for everyone? Is it the same standard? And the question here is, the same standard is, would a school that is religious based be giving a different standard than a school that's not? The state is saying no. We're treating every school the same. That's the neutral portion, and it's generally applicable to everyone. And if it's functionally discriminatory, if it's discriminatory against religion, if it's like, hey, we're targeting these religions, I think the school wins. But I think the reading of what I've seen so far, looking at what the Court of Appeals said, it seems like this is neutral and generally applicable.
And what I've seen here a lot lately, I think we all can agree over the last decade or so, we've seen a lot, the Supreme Court take up a lot of these type of cases to make some sort of judgment, issue their rulings on this, whether it has precedent or not. And so it's been much more common.
That is definitely something that I would agree with, that this Supreme Court does not run away from cases that are deeply rooted in case law and court precedent. That is, you're spot on. In the past, the court would have to have, a very, very narrowly tailored case before they will address something that could potentially overturn past precedent. But you've seen in this Roberts court has not strayed away from confrontational issues that will allow them to tackle and unpack cases that have a history of 40, 50, 60 years of precedent. I mean, Roe v. Wade, Dobbs decision is probably the easiest one to look at, where you can say, hey, other courts didn't want to touch it because precedent was well established. But they're saying, hey, no, we can look at this case and we will have to review it. I think some of the other ones are some of these, alphabet soup agency cases where the court has entertained, hey, you are asking for us to do a standard when looking at these administrative agencies that's their agencies don't even look the same as they looked, 50 to 60 years ago. So it's time for us to review. So for a number of these cases, the court is giving the rationale and the basis for why they are going through and relooking at them because of time. The same thing that for years has allowed cases to be protected is now going to be the same thing that allows this rendition of the court to want to review.
All right, that's going to wrap it up for this topic right here. As far as for our second topic on order in the court, when we come back, Khalif, we're going to be talking about a violent home invasion that happened in Statesville over the weekend. Concerns about stand your ground as far as the defense goes in this. We're going to talk about a little bit further about this one coming up as you're watching Order in the Court with Khalif and Brien. We'll be right back on Queen City News Plus. Welcome back to Order in the Court with Khalif and Brien today, as we're going to tackle our last subject here. Pretty tragic situation. Statesville man involved in a home invasion. It was killed during a shooting call. There was a recording that was happening during this. And describe the details here about this person that was trying to get into a home for a home invasion. And then the 24-year-old man decided he's going to fight back. And while the other partner there was a family member or somebody was sitting there, started recording everything.
Yep. Brien, you're all over it. This case hits on a number of issues in our state. I mean, this is a perfect law school example. Obviously, my heart goes out to anyone's family that died, regardless of how they're connected to this scenario. But when I taught law school, these are the type of fact patterns that I would want my students to try to unpack, because if you got a chance to write an essay where you're not just talking about one topic, but 4 or maybe 5 topics, then that could allow me to determine if my students had a good grasp of the context and the content that we were teaching that term. So, I mean, right here we got self-defense, defense of others, stand your ground, and castle doctrine. So those are 4 clearly applicable topics to talk about here. So the question of North Carolina, does it have stand your ground? The overwhelming answer is yes. It's codified in statute, North Carolina General Statute 14-51.3, that allows an individual to stand still. They have no duty to retreat before using force. Some states require that if you are fearful of imminent bodily harm and you believe that someone is a threat towards you, that you have a duty to retreat first. And then once your last clear chance to retreat is gone, then you may, take that opportunity to now use deadly force if deadly force is being used to you. And so, and again, bringing it to the test example, I would say sometimes to try to throw my students off, I would say, hey, well, this case is happening in California, maybe a state that doesn't have stand your ground. And then they applying the laws to another state. And so now you're giving the wrong law because you didn't catch that first thing, that we're not even in the applicable state. But back to this factor. So stand your ground is rooted in self-defense and defense of other. And it's pretty clear in our state where, do you reasonably believe it's necessary to stop an imminent unlawful attack? That's the standard. And is it justified? So it has to be force met by force. So Brien, if you're attacking me and I may be in imminent fear of bodily harm, but you're doing it with your fists, I'm not justified to now retaliate with lethal force, because your fists wouldn't be lethal unless you're some martial arts expert. But other than that, if you're just attacking me with fists, I can't now use a knife or a gun to defend myself in a lethal manner when non-lethal force was used. So would be the same with staying your ground, the same with defense of others, and the same with self-defense. Now, and I will say this: if it is a size discrepancy, say if you're 6'5" and I'm 5'2", and you're 300 pounds and I'm 100 pounds, yeah, your hands can then become lethal, because that size discrepancy would still allow you to potentially kill me with your bare hands and me not be able to defend myself and then need to use something lethal to do that. So it would be case by case, but those are the things that I think would play here. And then the last one is the Castle Doctrine, that remember I talked about, you have to be able to show that you're in imminent fear of bodily harm. Well, in the Castle Doctrine, a person that's in their home, it is presumed reasonable fear if the person is unlawfully or forcibly entering your home, motor vehicle, or workplace. So you don't even have to go further. If they have just come into your door, if they're attempting to get into your door, that's enough to be presumed you're reasonably in fear.
Yeah, and to be clear here, the person who shot the person that was on the reported home invasion, the person has not been charged.
Well, I think that would be typical. I mean, in North Carolina, we have affirmative defenses. That's a defense that will completely bar a charge from going forward. So at what state, what place do you allow that to take place? Sometimes it could be before charges are brought. Sometimes it could be charges are brought. It gets to the DA's office. They recognize that there's no facts to support this. They can't overcome this defense of others or self-defense or stand your ground, and then they toss it. But that happens routinely in our state, where a case won't even be charged because at the probable cause level, the officers believe that stand your ground prevents and stops the charge from coming. Sometimes an officer will say, nope, I'm going to charge him anyway. And then the prosecutor will now say, stand your ground should have been implemented in this case.
As a lawyer, if you're representing the person who did the shooting, what are you telling that person right now? What are you working with the DA in this case, or the police? Because would there be some sort of forensic evidence? Because you have also the video.
Yep.
Would that be admissible?
Well, a couple things. I mean, admissibility is once we get to the trial level, which is extremely far from this point, because we're still at probable cause. Is it more likely or not that a crime occurred? Is it more likely or not that that person committed the crime? We're still at probable cause level. We can't get past that. This person isn't getting charged. So I'll be working with, if I represent this person, it would be a pre-arrest representation, which is talking to the detectives, reaching out to them, ensuring that my client hasn't made any type of statements without me being present. Well, it's rare that I will let my client talk to law enforcement, period. But it would even be extremely rare for me to let them talk with law enforcement without me being present. And so typically I would want to talk with them about the facts, ensure that the story that they are telling is consistent. And then if there's things that need to be shored up, to ensure that no charges will be brought, then I would then at that moment allow them to talk to law enforcement. And I've done that probably 5 times in my hundreds of plus cases that I've done with dealing with homicides, just because it's never in your best interest to make a statement to law enforcement, because anything you say at some point could be used against you later. Like you hear it in the movies when they read the Miranda. Well, it's true. Your statements you say today, 4 years later, could be used against you in trial. So it's better not to have any statements so they can't use them against you later.
All right, good stuff today, Khalif. Appreciate you. Always your expertise and your time today. You've been watching Order in the Court with Khalif and Brien. That's going to wrap it up for us.
Queen City News Plus. Just search Queen City News on your smart TV's app store.